All right, hello, all right, good. Okay, so mics are working, cameras are working, you got capacity for about 500 people, and that's it. Over to you, Mr. Chair.
Good morning. Today we are here to hold a public hearing on the amendments to the Thurston County Code to update the Critical Areas Ordinance regulations. We'll be addressing the Planning Commission, which is a citizen volunteer advisory group that reviews land use and environmental concerns and regulations. The Commission makes recommendations to the Board of County Commissioners, who are the final decision makers on changes to the comp plan and county code. If you wish to testify, please make sure you sign in at the entrance to Building 3 and make sure you have a number. Each person will have 3 minutes to testify. We have a timer here. It's green for 2.5 minutes. When you have 30 seconds left, it will turn yellow, and when it hits red, then your 3 minutes is up. Your time may not be ceded to another person. I'll be calling out the numbers for oral testimony. When you hear your number, please come forward to the podium. If you miss your place in line, if you're in the restroom or something, let a member of the staff know, and we will get you back in. You won't have to wait and start at the back of the line. Please turn in your numbers as you testify so we can review them. Today's hearing is the Planning Commission's chance to hear testimony on the proposed changes to the Thurston County Code regarding revisions to the Critical Areas regulations. It is to help the Planning Commission in its deliberations on the proposed changes to the code. The Commission will not be answering questions today. If you have a rhetorical question, that's okay, but we will not be taking questions directly. We may, however, a Commission member may ask the speaker for some clarification or a member of the staff for some clarification. If that happens, I can allow you extra time if that ends up taking a little bit extra. If you have specific questions about the regulations, please submit them to the staff. There are comment question cards, or you can direct them to Andrew Phobos here on the end. Please address the Planning Commission directly.
We can't hear.
Oh, I'm sorry. Please address the Planning Commission directly. Do not turn around and start addressing other members of the audience, typically somebody that has an opposing view to you. We've seen that before. So please keep your questions or comments coming this way. Because space is limited, doesn't look too bad right now. We do have overflow rooms. And if this room becomes full, we may ask those who have already spoken or do not intend to speak to please go to one of the alternative rooms to finish viewing the public hearing. Please be respectful of everybody else in the room and the speaker. I will not tolerate any rude, unruly, or intimidating behavior. And if I witness it, I will have one of the deputies ask you to leave the building. We will have a civil hearing and all sides will be heard on this. We will take several breaks throughout the day, roughly 10 minutes at the end of every hour, and a 30-minute lunch break around noon. You may submit written testimony as well as oral. And that's it. With that, I will open the public hearing. We will begin with a staff presentation.
Thank you, Chair Lane. Good morning, Commissioners. Can everyone hear me? Try to speak into it. Okay. So since 2003, Thurston County has been in the process of updating its critical areas regulations. The process was put on hold from 2007 until about 18 months ago when Thurston County began its work on updating the ordinance again. The Growth Management Act requires all jurisdictions in Washington to review and, if necessary, revise their critical areas ordinance every 7 years. Thurston County's update was due in 2005. That process had begun in 2002 and led to a public hearing in late summer of 2005. Due to staffing and workload issues in the following years, the effort was temporarily suspended in 2007. Thurston County is one of the last counties in western Washington to update its critical areas ordinance. The Critical Areas Ordinance, or CAO for short, governs how development and redevelopment can occur in environmentally sensitive areas. Thurston County's CAO first went into effect in 1994 and has not been substantially reviewed since that time. A draft of the Critical Areas Ordinance update has been available on the Planning Department's website. To put the update in context, here's a little bit of background information on critical areas planning in Washington State. In 1990, the Washington State Legislature passed the Growth Management Act in order to accomplish a variety of goals, including reducing sprawl, retaining open space, protecting property rights, and protecting the environment, including our shorelines. The Washington State Growth Management Act directs all cities and counties in Washington State to designate and protect 5 types of critical areas. The 5 categories of critical areas that must be protected include critical aquifer recharge areas, or areas where rainwater infiltrates the ground and recharges drinking water supplies, geologically hazardous areas such as steep slopes, frequently flooded areas, wetlands, and fish and wildlife habitat conservation areas, including special consideration for anadromous fish such as salmon. State law also directs jurisdictions to use best available science when reviewing their critical areas ordinances. Thurston County's ordinance has not been reviewed since that direction was adopted into state law. The best available science mandate means that county staff and policymakers must review pertinent scientific literature to determine how best to protect critical areas. To date, this effort has meant performing research, working with experts in various scientific fields, and studying the science used by adjacent communities and completing their updates. Thurston County's wealth of natural resources contribute greatly to our quality of life. Critical areas function both to support human and wildlife populations, and the protection of these areas also factors into the safety of our residents. For example, regulations on building near frequently flooded areas and unstable slopes can help to protect people and property from harm. One habitat type that has received considerable attention in Thurston County is our prairie ecosystem. The U.S. Fish and Wildlife Service estimates that in 1850, more than 300,000 acres in the South Sound region likely supported prairies or other grassland environments. Today, less than 10% of historic prairie remains, with about 3% of the historic extent still considered high-quality habitat. Most of the remaining South Sound prairie habitat is located in Thurston County and on Joint Base Lewis McChord. Since at least 1984, state and federal natural resource agencies have documented that Puget Prairie, Oregon white oak woodlands, and the plants and animals that depend on them for their existence are at risk of becoming extinct. Prairies and Oregon white oak woodlands support several species of greatest conservation need as determined by Washington Department of Fish and Wildlife. In March 2011, the U.S. Fish and Wildlife Service announced that it was beginning an assessment of 4 prairie species to determine whether they merit listing under the Federal Endangered Species Act. In addition to habitat, prairie soils and the aquifers beneath them also provide for the natural storage of large quantities of water that today supply drinking water for many South Puget Sound communities. The proposed regulations under consideration for today's public hearing generally include the following. A new Title 24 is proposed to be added to the Thurston County Code to address critical areas for non-agricultural lands and uses. It would be known as the Thurston County Critical Areas Ordinance. The new title has been reformatted to try and make it better organized and easier to navigate than the previous draft in 2005. Chapter 1715, or the existing Critical Areas Ordinance, is proposed to be amended to remove references and regulations for non-agricultural uses, remove sections that are proposed to be moved elsewhere in the Thurston County Code, and to update department names and references. This chapter would also be known as the Thurston County Agricultural Uses and Lands Critical Areas Ordinance. Title 20, Rural Zoning, is proposed to be amended to add the residential density standards currently in Chapter 1715, affecting properties zoned rural residential and resource 1 unit per 5 acres and rural residential 1 unit per 5 acres. To update and clarify other density standards and minimum lot sizes, update exempt buildings, add a chapter to move regulations from Chapter 1715 regarding development around Summit Lake and update department references and references to Chapter 1715 and the proposed Title 24. Title 21, the zoning ordinance for the Lacey Urban Growth Area, or UGA, is proposed to be amended to add the residential density standards currently in Chapter 1715 affecting permitted density in residential zones, and to update references to Chapter 1715 and the proposed Title 24, as well as updated department names and references. Title 22, the Tumwater Urban Growth Area Zoning Ordinance, is proposed to be amended to update department names and references, as well as references to Chapter 1715 and Title 24. Title 23, the Olympia Urban Growth Area Zoning Ordinance, is proposed to be amended to add the residential density standards currently in Chapter 1715 affecting permitted density in residential zones, and to update references to Chapter 1715 and the proposed Title 24, as well as updated department names and references. A new chapter is proposed for Title 17 Environment to revise the standards currently in the Critical Areas Ordinance. The proposed chapter is 1730 Noxious Weeds. Planning for, designation, and enforcement of noxious weeds in Thurston County is done by the Noxious Weeds Control Board through their annual plan update. In all other sections of the Thurston County Code, all other references to the Development Services Department are proposed to be changed to the new department name of Resource Stewardship, and all references to the Roads and Transportation Department, except Title 15, will be changed to Public Works Department. All references to Chapter 1715 will be updated to reflect proposed Title 24 for non-agricultural uses and Chapter 1715 for agricultural uses. All right, so notice of the public hearing was advertised in a variety of ways. The Olympian published a notice of public hearing on November 16th, 2011. The Nisqually Valley News, which is Thurston County's newspaper of record, also published a notice of public hearing on November 18th, 2011. 3 newspaper articles that mention the Critical Areas Ordinance hearing were recently published in the Olympian on December 4th, 5th, and 7th, 2011. And the Thurston County Planning Department also advertised the hearing in 2 emails to our webmail subscriber list, which reaches about 650 subscribers. Information on the hearings was provided via email on November 22nd and December 6th, 2011. And the Planning Department also recently produced a YouTube video to provide information on the hearing. The public hearing has also been a topic of several recent Planning Commission meetings and has also been advertised on the county's general webpage and Planning Department webpage for some time. The hearing has also been advertised by several outside community groups throughout their own publications. As Chair Lane indicated earlier, the Thurston County Planning Commission is a volunteer advisory board to the Board of County Commissioners for Land Use and Environmental Policy and Regulation. Following the public hearing, the Planning Commission will hold several work sessions to discuss public comments and issues brought forward during the hearing, prior to giving their recommendation to the Board of County Commissioners, who ultimately make the final decision. The Board of County Commissioners will also hold a public hearing on the Critical Areas Ordinance sometime during early 2012. To be notified of that public hearing, please make sure that you sign up at the sign-in table or sign up for the Planning Department's webmail service. For more information, please visit www.thurstonplanning.org. To stay informed about Planning Department activities, you can sign up to receive email notifications by clicking on the webmail link at the top of our website. Lastly, the Planning Commission is currently accepting written comments on the Critical Areas Ordinance update and will do so until 5 p.m. on December 23rd, 2011. You can submit comments to myself, Andrew DeFobis, via email or regular mail. My contact information is available both at the podium and out at the sign-in desk. And written comments will all be forwarded to the Planning Commission for their consideration at the end of the public comment period. And that concludes my staff report.
Okay, with that, I will begin. We'll start with the introduction of planning commissioners, starting with Kathleen.
Kathleen O'Connor, District 3. Liz Colbert, District 2.
Liz Earl, District 3.
Ed Fleischer, District 2.
Chris Lane, District 1.
Scott Nelson, District 3.
Jennifer Davis, District 2.
Kristen Spalding, District 1.
Bill Jackson, District 1.
Okay, with that, we'll get started. When your number is called, please come in, turn in your number, and state your name and address for the public record. Number 1.
Wanted to or not. Well, my name is Mark Kelly. I live in Lacey, 3419 Lynn Court. It's hard for citizens to have meaningful conversations with their elected officials. Commissioner meetings are held on Tuesday afternoon when people are at work. Commissioners remain silent during public testimony, and they decline any debate. and they limit testimony to 3 minutes. At planning board meetings, state and federal bureaucrats are given 3 hours to present their case for the prairie ordinance or the gopher ordinance. The thousands of people who had their property rights revoked are given 3 minutes. Now, you have valid reasons why you made those rules, but the result of every one of them blocks any real dialogue between voters and their elected officials. They limit any meaningful contact. When Fish and Wildlife released its initial pocket gopher study, no county in the state enacted an ordinance, not even our neighboring ones. They rejected it out of hand. Thurston County, on the other hand, created the gopher ordinance and basically revoked the rights of 57,000 property owners and county residents. 6 years later, the complete study is out, and the gopher is not an endangered species. Think of all the damage that was done to those county residents and how easily it could have been avoided if you would have just been open-minded and listened to us. That's more for commissioners than it is you guys. Now, I see that the planning board is considering granting permission to allow the Lot Clean Water Alliance to pump treated wastewater, or sewage if you prefer, into our drinking water supply. They already have permission to do this at their Hawks Prairie facility. In case the audience doesn't know who Lot is, they're a public partnership regulated by the county to dispose of our wastewater. They're also the largest contributor to the Capital Land Trust, of which Commissioner Sandra Romero is a board member. Dennis Burke is an environmental engineer who has designed wastewater systems for cities like Philadelphia and others across the country. He's had as much experience and knowledge about wastewater disposal than anybody in the state. He lives right here in Thurston County, and he's adamant against Lot being allowed to use this proposed method and claims that it's dangerous to public health. I've heard him say that no developed nation in the world would use this method. Is he right? I don't know. But the point is, either do you, because instead of benefiting from his lifetime of experience, you limit him to 3 minutes. What can you learn from this industry expert about something as complex as the treatment methods, hazards, and past results of this method in 3 minutes? The big problem here is that Lot might be contaminating our drinking water. Like in the movie Aaron Brockovich, contaminated drinking water can take years to be discovered and at great cost to human life. To make matters even worse, Lot is steaming ahead with their second plant before they complete their privately ran tests on how the facility at Hawks Prairie is affecting our drinking water. You have the smartest guy in the room available. Please talk to him. The gopher ordinance can be easily reversed. You can't reverse contaminating our water supply. Thank you. And thank you for all your work, too.
Number 2.
I'm Paul Sparks. I'm here representing the Olympia chapter of Trout Unlimited. We have 40 years of investment in clean water and water supplies in this county. I began some years ago as a 4-year stint on planning for the Water 13 water plan, which would have been the first comprehensive water plan in this county. As a rural resident, I live at 14205 Military Road southeast to Nino. I live on the Deschutes River. I have a real concern with water. Every drop of water that most of the people in this county drink comes from the Deschutes Aquifer. The aquifer is shared with the lakes in the county and the Deschutes River. In 1989, minimum flows were established for the Deschutes. We have not met those flows at any year since then. Waste that goes somewhere into the ground somewhere else on top of that watershed someday ends up in my water supply. That's a real concern. To turn back to the process and the document before us, I think on the whole this is a good document. You will receive a lot of heat today. That should not bury the fact that you've done well in most of the parts of what you do. I do have some particular comments. First, one thing that has been in the minds of people involved with this kind of planning for some years is the reluctance of elected officials to enforce the ordinances. I think that you have to have some sort of argument that goes forward to the commissioners that talks about implementation. And implementation of these things should include some degree of enforcement and possible incentives. And we have mechanisms for taxing in place that could fund those incentives. Secondly, you do an excellent job with your setbacks on riparian zones. You have not applied that in the same way to marine setbacks. The Washington Department of Fish and Game recommends 250 feet. I think we should look at that as our standard. Thirdly, the new draft follows a pattern of many previous processes and rules on what used to be called Class 4 and 5 streams. For the great part, the streams in our county were never ground-proofed, as they were in no part of the state when the regulations went into protecting these things. These also happened at about the same time that our Puget Sound salmon populations crashed. As a result, many of those streams, which will, in normal high water periods, support fish, especially coho, are now not going to be protected to the same degree that they should be. I would urge and argue that any stream that historically, a feeder stream to our big streams, supported coho should be protected to the same extent that we do the recognized fish-bearing streams. The fourth point I try to make, and this one is going to seem a little bit strange to some of you, it is something that has never been considered in these deliberations. The Urban Growth Management Act created a situation that was unforeseen, and that's the backyard horse. There are probably more horses in this county than there were when there was the principal mode of transportation. Land cleared 5 acres creates a tremendous runoff problem and pollution problem that is not considered because it's not the way we understand agriculture to be. One of the best ways to get a hold of agriculture, runoff, and pollution is to look at the problem of the backyard horse.
Could you wrap up, Paul?
Thank you.
Number 3?
Good morning, and thank you, Chair and Commissioners, for letting me speak today. My name is Linda Saunders. I'm the Director of Conservation at Wolf Haven International. I live at 271 West Wynwood Drive, Shelton, Washington. Thanks for the opportunity to comment on the proposed update to Thurston County's Critical Areas Ordinance. Wolf Haven has a strong interest in the Critical Areas Ordinance, in particular those sections that deal with prairies and oak woodlands. Prairies are a very special part of Thurston County's heritage. The open grasslands of the prairies attracted our first settlers, with the many prairie-related place names around the county a reflection of that. And today, prairies are home for a suite of unique plants and animals, several which occur at few other locations in the world. Wolf Haven International is a private landowner in Thurston County and have approximately 55 acres of prairie on site. We made a conscious decision over a decade ago to begin actively restoring our native prairie habitat, and with the help of numerous partners have made tremendous strides. Our prairie is relatively small in size, but it serves as a stepping stone for the many butterflies and other insect species to adjacent prairies that are being restored in the county. Native prairies provide direct benefits to humans as well as habitat for the various insects, birds, and mammals residing there. They're home to many important pollinators besides the butterflies and moths that we always hear about. We have many species of native bees and bumblebees on our site, and bumblebees are critical pollinators to many agricultural crops in our areas. We're concerned about pollinators and knowing how important they are to the health of our native plants and these agricultural crops. The prairie created some of the best soils in the world. Some of the richest farmland in the world can be found where the prairie once flourished. And along the same lines, the rocky soils in the prairie allow for maximum percolation of rainwater, which is key to the recharging of aquifers. I know that's another issue you're dealing with. It's always possible that medicine or a drought-resistant food crop someday could be developed from prairie plants. And finally, native prairie draws visitors to the South Sound, bringing us revenue and to all our local communities. As private landowners, we invite the public to experience the many butterflies, birds, and native plants as part of their visit to our wolf sanctuary. We believe that the native prairie habitat in the South Sound is an extremely important habitat that's quickly disappearing from our landscape, and we're concerned that so much of the native prairie habitat is already gone. We support the county's proposed Critical Areas Ordinance, which will protect rare native prairie habitat in the South Sound By updating your critical area ordinance and incorporating interim prairie and oak woodland conservation protection, Thurston County is being proactive with a science-based regulation that protects unique and rare prairie habitat. The proposed regulation can reduce the possibility that native species will be federally listed under the Endangered Species Act and therefore limiting greater restrictive federal action. And by adopting the critical area ordinance, it'll retain regulatory control at the county level, which is generally better for all interests involved. Thank you.
Thank you. Number 4?
Good morning, Planning Commission members. My name is Jim Simmons, and I am president of the Thurston County Realtors for 2012. Thank you for giving us an opportunity to speak before you regarding this very important issue for our county. I know that some of you have been working on revisions to the critical area ordinance for 5+ years, and we thank you for your volunteerism. Realtors have always promoted and supported the quality of life in the area in which we live and practice. We believe in sustaining and protecting the environment, but at the same time, we know the county needs to accommodate future growth. We believe that too much restriction can affect property values in the future while devaluing the existing property values and possibly taking away the enjoyment and usage of private property. Restrictions further reduce the inventory of buildable land. Thurston Region 2040 population projections are estimated to add 170,000 additional residents between 2010 and 2040, reaching a regional population of nearly 422,000 in 2040. These projections show that we need to maintain a policy to ensure there is no net loss of housing in Thurston County. Based upon our involvement in this process over the past 5 years and on our review of the proposed regulations together with our knowledge of Thurston County, we would ask that as each of you reviews the testimony provided that you ask why we need to change from our present standards. Then weigh the benefit to be realized with the incremental change from today's standards to the environment, with the potential cost with losses to existing and future housing opportunities, as well as jobs in the county, including impact to our county's working farms and forested lands. Finally, as you do this evaluation, remember that we are not counting the environmental impact of the many generations who've lived and worked here since the mid-1800s. Through previous evaluations of our natural environment and the standards set forth over the years, the county has already taken corrective steps to improve our natural environment. We firmly believe that no two parcels of land are exactly alike, and development standards that treat every property the same ultimately will not lead to the best environmental outcome. Attached is a sample of a potential solution for a balanced approach. This concept is called adaptive management. The concept has a common sense approach that looks at an individual property and determines the proper restrictions and variances required to balance preservation and the enjoyment of private property. Without an adaptive management plan similar to the one in effect in Mount Vernon, it is entirely possible that any property located within a shoreline or slope or habitat buffer could be classified as non-conforming. And this classification could have adverse effects on the insurability and or marketability of the property, and also could restrict any improvements the homeowner might wish to accomplish. Realtors have presented this concept to the Planning Commission, County Commissioners, and staff for review. We encourage you to review this material again and include it in the critical area ordinance revision. Again, thank you for the opportunity to speak, and please contact us at any time. We are working with you to maintain the quality of life we all love and enjoy in Thurston County. Thank you.
Thank you. Number 5?
Good morning. My name is Angela White, and I'm representing the Olympia Master Builders this morning. I almost said this afternoon. Planning Commission members, I appreciate the time you're taking to review the Critical Areas Ordinance. It's quite extensive and filled with lots of information. Our members have taken some time since your draft on November 18th was released to review and look at it from the eyes of people that are going to be actually using it in their daily world. And they did see that it's added some predictability, and the county's actually clarified their positions in some areas so that it's going to make it an easier document to understand. But with that in mind, there are several areas that you could be improving this document. We have hired a scientist, Dr. Lyndon C. Lee, who's a PhD and an expert in wetlands, and we commissioned him to review the wetland portions of this document. And he has found several areas with his scientific background that you could do improvements to add flexibility. And as the realtors mentioned about the adaptive management approach, he compared your document with the Mount Vernon document. And so I think you'll find this information very interesting. I appreciate you giving us the time here today to talk. This is very extensive, and so obviously I cannot go into it all, but I will email a copy of this and hand this copy to you today. I appreciate the time. Thank you.
Number 6.
Good morning. My name is Peggy Bruton, and I'm going to be speaking today as on behalf of the Thurston County League of Women Voters. I myself live at 1607 East Bay Drive in Olympia. The League of Women Voters we always base our comments on previously taken positions, and I'm going to be turning in to Mr. DeFovos my full remarks, which will state those positions, but I won't take up time with them now. They're all in favor of the need to protect resources for future generations and our convictions about how this should be pursued. We've been a long-time supporters of protecting critical areas and protecting resources, and we're strongly in support of this effort by the county, and we feel it's high time it's done. We're urging the county to proceed without delay. I'll just make a couple of points, and the first one is that we share the concern of some previous speakers about the need for the precautionary approach to protecting the aquifer recharge areas. We basically support the plan that the county has come up with. However, we're still concerned that since there's so much unknown about some of the constituents to the waste stream, that we think that the protective measures should err, if at all, on the side of conservatism, so that the protections are stronger perhaps than it's felt, since we don't know, and then can be relaxed if it's learned that these constituents aren't indeed damaging and so forth. So we simply we know this is a difficult problem dealing with the CARA, I guess it's called, and we think it should be we should just really look out for the future and make sure that we don't allow things to go bad. The cost of remediation would be much, much greater than, I believe, than the cost of doing this now. Also, I've heard people complain about the over-regulation, like their laws, we have shoreline rules, we have critical areas rules. I believe that this kind of layering of rules is actually helpful, not just because it affords us a better level of protection, but also because I think it affords better flexibility. So I would be in favor of the Critical Areas Ordinance actually expanding the buffers for undeveloped shoreline. I recognize that and I should be saying we because I'm speaking for the league. Anyway, I'll turn in the rest of my remarks to Mr. DeFocus. Thank you very much.
Number 7.
I'm Eve Johnson at 1716 Water Street Southwest in Olympia. My concern is primarily one that I developed on my way in here. I had to pass 8 boxes of bottled water. I thought you were protecting critical areas. And this bottled water costs more than gasoline that brought you here. I think that we should drink the water out of the tap. We have very good water in Olympia, and it's ridiculous when you're protecting critical areas that you're buying water in a bottle, which I have to pay for, I presume. It wasn't free, and I pay already for the water that comes out of the tap. I don't know why I should be paying for the bottles. And the bottles are themselves a problem because they fill up the landfills. So having said all that, I think that I will now get down to the subject of the hearing, which is the Critical Area Ordinance. And I feel that one of the problems is that it isn't strong enough, that you have not really thought carefully about the precautionary principle, which is that in any case, you assume the worst outcome and that you protect against that really bad outcome, so that all of our property and the land that we are living on now is preserved for the next generation. And I think that's really what you all are supposed to be doing, is taking a look at what is good for us today, but also that you're seeing to it that it is available for our children and our children's children, so that we are really temporary stewards of the land and of all the resources that we approach. And we are not to use them all up, but that we are to see to it that they are sustainable and that they are available for our children and for our grandchildren. And I hope that you will take that into consideration when you're preparing this ordinance, because I think that's really what the legislation is all about. Thank you very much.
Thank you. Number 8.
Thank you very much. My name is Glenn Morgan, and I live between Tenino and Rochester. And I'm also the project manager for Stop Taking Our Property, Thurston County. And I appreciate the time the Planning Commission has spent and will spend on this critical area ordinance. Many concerns exist about this ordinance, and a more detailed accounting of these concerns will be submitted to the Planning Commission before your deadline for the receipt of written comment closes. My primary concern about the CAO revolves around the complete failure of Thurston County staff to consider the property rights of average people affected by this ordinance. Private property rights are the foundation of individual freedom, individual prosperity, and community prosperity. Ignoring these rights or just taking away tangible portions of these rights is a continuation of Thurston County's recent track record of putting people last as policy. It is a shame and unfortunate that our community will be forced to correct these wrongs over time, if not for us, then for our children and future generations. Another significant concern with this ordinance is that, for the most part, we're looking at an ordinance that, like the 2005 draft, fails to account for the economic impact these new restrictions will place on our communities. Under the GMA, you are required to consider these impacts, but there was no documented effort to do so. Thurston County has always ignored the economic impacts of these ordinances. Specifically, economic harm will be inflicted on all county taxing districts like fire districts and school districts. And under federal law, Thurston County should be required to have economic impact statements for each of those districts that request them. It is worth also noting the complete abdication of responsibility by Thurston County staff to make even the slightest effort to avert a federal listing of the pocket gopher, which only required a fraction of the money already wasted by Thurston County, and it ended up being funded by local communities and school districts like Yelm and Rochester, or Yelm and Tumwater, to fund a real population study of the rodent. The glaring and embarrassing flaws in Thurston County's inability to understand any science related to the pocket gopher populations only help to highlight the lack of credibility for any claims that Thurston County has ever made about the portion of the CAO that involves the oak tree or the prairie habitat. The portion of the CAO that includes the emergency prairie ordinance should be removed from the current draft and reviewed under a true peer-reviewed scientific evaluation, which has never been done. Clearly, this oversight and review is desperately needed here in Thurston County. There are additional concerns which we'll submit to you in more detail regarding the invention of the 300-foot buffer with no science behind it, the hostile creation of the non-conforming uses throughout the ordinance, and the radical impact on buffer zone definitions and just more mundane specific issues. However, while it is easy to get lost in the weeds, the trees, and the gophers, it is sometimes necessary to stand back and look at the forest, or the prairie, if you will, and our community, and put this all in some type of perspective. Ultimately, there's no way to dress up this ordinance as anything but a way to justify harming those who are most vulnerable in our community and to call it good. It is a tool to deny future generations the ability to afford a home, inherit a home, or live in a healthy, rational, modern society. Sure, some will profit from this effort. A wealthy and politically connected resident recently wrote a letter to the editor and claims that his mansion will increase in value by preventing others from building their dream homes. He may be right, and he may profit from the harm that's inflicted on the rest of us. High-paid consultants, attorneys, and job security for Thurston County staff, and some might be those with benefits, and pretending to protect the environment while steamrolling over the small property owner is not good for our community. This ordinance puts people last once again, and while I know that this has become policy at Thurston County, we would like to suggest considering making our suggested changes and at least look at those. If our commissioners then choose to ignore your efforts to protect the average citizen and put people first for a change, then let it be on their shoulders and not yours. Thank you very much.
Thank you. Number 9.
My name is Tom Holtz. I live at 6135 Main Street Northwest in Olympia. I am in favor of the critical area ordinance. I think that, well, I should say I know that in order to preserve Puget Sound, we need not only a strong critical area ordinance, but we need extraordinarily strong low-impact development regulations. This is not subject to debate any more than the gravitational constant is up for debate. This is science. So the question is, do we want to save Puget Sound or do we not? Currently, we have fish loaded with mercury. We cannot eat fish more than once a month. We have toxins in the sediment. We have toxins in the sewage treatment plant discharges. And we have extraordinarily high concentrations of toxins in Puget Sound. The next 10 years or so will determine whether or not Puget Sound survives. I say again, without the critical area ordinance and without low impact development regulations, we can say goodbye to Puget Sound now. And I thank you very much for your attention.
Thank you. Number 10.
Thank you. My name is Carla Fowler. I'm with the Lot Clean Water Alliance. Our address is 500 Adams Street Northeast in Olympia. We appreciate your efforts to update the Critical Areas Ordinance, and of course our particular focus is the Critical Aquifer Recharge Areas chapter. As the public wastewater utility formed by Lacey, Olympia, Tumwater, and Thurston County, LOT's mission to preserve and protect public health and the environment puts us on the same side as the county when it comes to water quality protection. We do not differ in our goals. Our 4 government partners spent 4 years developing the long-range plan that has reclaimed water production, distribution, and use as its core. All possible alternatives for wastewater management were considered. The entire plan was driven by public values and extensive environmental evaluation. The resulting plan melded the best of both technological treatment to a very high water quality level and natural filtration through groundwater recharge. As currently drafted, the CARES chapter identifies contaminants of emerging concern as an issue related to groundwater infiltration of the reclaimed water. The draft proposes the ultimate measure of advanced treatment, such as reverse osmosis or nanofiltration, as the only solution for all infiltration projects. In doing so, it overlooks the already high level of treatment that the water is receiving, additional infiltration provided by engineered recharge basins and soil aquifer treatment, site-specific environmental conditions, existing very stringent regulations, and unintended environmental impacts that could result from requiring the advanced treatment. Our primary recommendation is to not impose advanced treatment across the board at this time. Instead, let's take the time to do the local science to determine what's really needed. LOT is beginning a major 4-year groundwater recharge scientific study to do just that. Until it's done, we can continue to rely on the hydrogeologic studies, the computer modeling, monitoring, and other stringent regulatory requirements that already apply to each infiltration site. This will allow precautionary, site-by-site, adaptive management, and still allow advanced treatment when and where scientific results show that it's actually needed. We have prepared some more extensive written comments with greater detail. We've also had 2 consulting firms compile best available science reports and compilations of scientific documents that are referenced therein. We're still preparing the CDs with the science reports, and we'll submit the expanded comments reports and CDs as a package during this coming week. Thank you.
Number 11.
Hello, my name is Justin Cover. I live at 522 Lily Road in Olympia. And if this were a council meeting, I would ask Commissioner Valenzuela if she remembers the study that I offered into the record over a year ago about the Mazama pocket gopher, the 2000 Thurston Caraway study that I was told was too old to consider. The new Krippner study, funded by the Thurston County Economic Development Council, cites the study that was dismissed by the Thurston County Commission, like that study was cited in the 2005 Stinson report. I hope, beyond hope perhaps, that our Thurston County Commission, and this commission also, will finally see the light. I hope they will see that there is a public interest in taking the effect of ordinances on private property into account. That science should dictate our policy and not the other way around. I hope that all of us will insist on a higher standard. I hope that our environmental policy will insist on real empirical data, like the efforts that resulted in the Sitcombe waterway being delisted from EPA's national priorities list right here in the Puget Sound. Real empirical data, like that used to demonstrate the danger of CFCs to the Earth's ozone layer. The people of Earth achieved the Montreal Accord, still the model for global cooperation, and succeeded in curbing CFCs in our atmosphere because when the proof equals the truth, we can bring the world together. The proof has not equaled the truth in any of the Board of Commissioners' proposals. They cannot show us any data so strong as the reaction of chlorine radicals in the Antarctic caused by CFCs. There is no record of population for the Mazama pocket gopher so convincing as the data that showed the waters of Commencement Bay becoming healthier. You have shown us computer models that are missing key variables. The Commission has said that they were frightened and hid behind metal detectors. They have ginned up support amongst their key activists who have called their opponents names, suggested they leave America, challenged our loyalty to the Democratic Party, and engaged in all manner of hysteria, but never have any of them engaged in the actual facts or science of the CAO. And now we see why. Now we see that the Thurston County Economic Development Council's independent study uses state and county data to debunk the claims of the Stinson report and of our Thurston County Commission. Commissioner Romero sits on that board, so I'm guessing there is no bias in favor of Stop Thurston County. I am hoping beyond hope that they will finally do what's right for all of the people of this county, and not just for politically connected real estate speculators like Sam Garst, who said it better than anyone in the Olympian yesterday. Just what the CAO is really about. The Critical Areas Ordinance is about this commission, the Thurston County Board of Commissioners, selling out the environmental movement to real estate speculators like Sam Garst, Bob Jacobs, Walt Jorgensen, Zena Hartung, and Jim Lazar. I am hoping beyond hope that our commission will come to their senses and realize that this version of the Critical Areas Ordinance cannot and will not stand in Thurston County. In any event, there is an election coming, and I will see you all there. Thank you very much.
Thank you. Number 12.
Mr. Chair, Commission members, my name is Kenneth Neal. I'm a licensed engineer geologist, and I've been practicing in Washington since 1975. I currently operate a consulting business, Kenneth Neal and Associates, out of my home at 3314 Gibraltar Court, southeastern Olympia. I'm the person that assembled the Geologist Licensing Act and served 2 terms on the licensing board. I've sent 2 memos and other comments to the board throughout this process. I have too many concerns about this proposed act to discuss all of them today, but I've got a couple of points that I want to cover. Number 1, I believe that use of the Pierce County model for landslide hazard geotechnical reports is a mistake. For a number of reasons. One is that the requirements for report content are unbalanced. They contain very detailed specifications for data to be collected for boring logs, but don't seem to require the same level of data for say, exposures or test pits. The standard of practice for describing and classifying soils in the field is the Unified Soil Classification System Visual Manual Procedure, and that's ASTM D2488. The requirements for descriptions that you have in the draft are not consistent with USCS procedures, although you state in several locations that you intend to follow ASTM. I don't want to get into the details, there's just not enough time. What we do as a practice on boring logs is, in the field, we follow the ASTM standards, log soils at a scale of 1 inch equals 1 foot, and then reduce the scale after we synthesize the data for design logs that contain all the elements that are needed for design or other applications. There are other issues with scales specified for cross-section and so on, which need some modification. My experience in using Pierce County regulations is that I've always got to go to the county and negotiate with them about what the report will contain so that I can do something that's meaningful. Remember that someone's got to review these reports, and I think the staff is going to be overwhelmed, particularly if the volumes and types of data specified are incomplete or inconsistent. And my suggestion is that you use the Mason County regulations rather than Pierce County's as a model. The reason is Mason County's model is directed at providing the types of illustrations and analyses that are useful for planning and design, rather than a bunch of raw data. The other point, and I want to go through this quickly, is that the use of development proposal site as applied in these regulations is ludicrous.